that he found the above utterances unparliamentary and constituted conduct and becoming of a member of parliament, more so a minister. That the rules provide adequate remedies to members of parliament who are dissatisfied with anything done by the House, and that as members of parliament they were expected to set a good example in terms of compliance with the rules and not act in a wanton manner like Honorable Namuganza did in the video clips he presented to the committee. That he found Honorable Namuganza was not a first-time member of parliament, and she was also a minister who was aware of the procedure for challenging decisions in the House, and she should therefore not be excused of her misconduct. That they took a decision to express their dissatisfaction and displeasure in the only way permissible in the Constitution, which was by passing a vote of censure against Honorable Namuganza to deter similar misconduct in the future and restore the dignity of Parliament. Honorable Tuichire urged the committee to consider the evidence of the past conduct of Honorable Namuganza as it was intended to prove that Honorable Namuganza was not a first-time offender who should be given a lenient punishment, and that the only befitting punishment was censure, so that she can serve as an example to other members who plan on engaging in similar misconduct in future. 6.3 submission by Honorable Gilbert Olanya, MP Kilak County. Honorable Gilbert Olanya made the oral submission as follows: that the previous conduct of Honorable Namuganza should be taken into consideration in determining this matter, since it served the purpose of proving that Honorable Namuganza was a habitual offender who ought to be severely punished. B, that he associated himself with the submission of the move of the motion, Honorable Court John Amos. 6.4 submission by Honorable Yona Musinguzi, MP Ntungamo Municipality. That the framers of the Constitution envisage situations of ministers with questionable conduct, such as Honorable Namuganza, and that is why they enacted Article 118 of the Constitution. That he associated himself with the submission of the move of the motion, Honorable Court John Amos. Honorable Amero Susan, District Command Representative, Amuria District. That the attack on the marriage of the Right Honorable Speaker by Honorable Namuganza was uncalled for, since this was a private matter which was not in any way related to the matters for which she had been investigated. B, that she associated herself with the submission of Honorable Court and appealed to the committee to admit the evidence presented. 6.6 Honorable Silwani Solomon, MP Bukoli County Central. That Honorable Namuganza was in the habit of attacking fellow leaders, and that she had on several occasions attacked the former Speaker of Parliament, Right Honorable Rebecca Kadaga, and the Chawazinga of Busoga, which culminated into her suspension from the Busoga Parliamentary Caucus. He had used evidence of a flash disk appendix 29 containing a video recording of entitled Clip 1 and another entitled Namuganza Attacks Kadaga in the 10th Parliament, wherein Honorable Namuganza allegedly attacked the Right Honorable Rebecca Kadaga, the Chawazinga of Busoga, and other leaders of Busoga in Busoga, and incited the public to stone the Chawazinga of Busoga. B, that as a minister, Honorable Namuganza was expected to portray a good public image. For her to attack the Chawazinga, her conduct was unbecoming of a leader. C, that the evidence he had used showed that Honorable Namuganza was a repeat offender who had on numerous occasions attacked the presiding officers of Parliament, and that the past had been a subject of investigation by the Parliamentary Committee and other parliamentary groups for her unbecoming conduct. And lastly, that as a repeat offender, Honorable Namuganza should be severely punished by censoring her. Lastly, Honorable Sarah Opendi, District Command Representative, Tororo District. Honorable Sarah Opendi made an oral submission as follows: that she was a member of the ad hoc committee on the Nakawa Naguru land and participated in the proceedings of the Committee on Rules, Privileges and Discipline on the inquiry into the allegations of misconduct and misbehavior against Honorable Namuganza as a witness. That she was appearing before the committee to disprove the allegations that Honorable Namuganza made in the House on 7th December 2022 during consideration of the report on the Committee on Rules, Privileges and Discipline, to the effect that the censor proceedings were initiated against her to set a personal grudge relating to the legal issues allegedly surrounding the marriage of the Right Honorable Speaker of Parliament, Anita Aneta Mong. That Honorable Namuganza reiterated the same allegations in an interview with NBS TV held on December 2022 on Baba Television. that the marriage of the Right Honorable Speaker began with a traditional marriage ceremony on 30th July 2022 and a wedding on 31st July 2022 at which she was the matron of honor, and yet matters leading to the sense of Honorable Namganza were raised by Honorable Silwani Solomon during a sitting of Parliament held on Wednesday, 13th December,
Procedure.
13th July.
Procedure.
So, Speaker, Rule 109, under which the chair is reporting, restricts him to leading and actually provides an opportunity to the mover of the motion himself to make the case. But the chair is doing both. The procedural issue I am raising is whether the chair should not be briefed to allow, as the rule says, the mover of the motion to make the case, Mr. Speaker.
This is the report, and we'll do.
Thank you. Please, colleagues. The chairperson of the committee and the committee, we are given a task to establish whether there is a prima facie case or not. For them to do that, they had to scrutinize evidence deeply. And they must, whatever they found is not theirs. It's for the House, which will guide the House. So, to me, the chairperson is reading. And for clarification, the chair, the mover of the motion will only come in, otherwise he presented all the evidence to the committee, and this is the evidence which the committee has scrutinized and is giving us a report. So for him, he will only come in if the committee maybe did not agree with his evidence or left out very substantial evidence. And I expect the move of the motion not to take more than 2 minutes, because all his evidence has been presented in each and every way. So the chairperson is reading us. And the rules don't give you a limit to where he reads you. He can lead us until tomorrow. So that's so chairperson, please continue reading us. But don't lead us too far.
Thank you, Right Honorable Speaker. That the marriage of the Right Honorable Speaker began with a traditional marriage ceremony on 30th July 2022 and a wedding on 31st July 2022 at which she was the matron of honor, and yet matters leading to the sense of Honorable Namganza were raised by Honorable Silwani Solomon during a sitting of Parliament held on Wednesday, 13th July 2022, which was presided over by the Right Honorable Deputy Speaker. Therefore, the issues allegedly surrounding the marriage could not be the cause of the censure proceedings against Honorable Namganza. Lastly, that the allegations were malicious, unfounded, and not true, since the Right Honorable Speaker had not presided over the proceedings related to or dealing with any matter involving the sense of Honorable Namganza, and there was nothing personal or a conflict between her and Honorable Namganza. Honorable Saropendi adduced evidence to the Hansard of the plenary proceedings of Wednesday, 13th July 2022, Appendix 30. Now, honorable members, before we had to look at the evidence and see which one is admissible and which one is not, we thought we would also be clear on the appearance and the defense on Honorable Namganza. Honorable Namganza did not appear before the committee as required, despite having been informed of and invited for the meetings of the committee on Thursday, 12th January 2023, to receive the submissions, cross-examine the witnesses that were to appear before the committee if she so wished, and to further appear on Friday, 13th January 2023, to defend herself against the allegations in the motion. Mr. Pande Norman appeared before the committee on Friday, 13th January 2023, claiming that he had instructions from Honorable Namganza to represent her, but he did not present proof of the said instructions. What this means is even the minister can come here and deny having sent someone, because we are not sure we met the right person. However, in his submission, Mr. Pande informed the committee that he had perused through the attachments to the letter inviting his client, Honorable Namganza, to appear before the committee, The committee granted Honorable Namganza another opportunity to appear before it and defend herself against the allegations in the motion and in a letter dated 13th January 2023, inviting her to appear before the committee on Monday, 16th January 2023 at 9 a.m. In the same letter, the committee asked Honorable Namganza to confirm whether she had instructed Mr. Pande Norman to represent her in the proceedings of the committee as her counsel. On Monday, 16th January 2023, the committee waited for Honorable Namganza the whole day, but she neither appeared nor sent a representative. As earlier noted, the committee transmitted the evidence it received from the witnesses to Honorable Namganza on 12th and 13th January 2023, but she did not respond to the allegations contained in the motion. She did not adduce any evidence to disapprove any allegation made by the witnesses or rebut the evidence adduced by the witnesses. The committee took cognizance of the principle in the case of Fox Odoi versus Attorney General, Constitutional Petition number 54 of 2013, that the right to be heard is limited to the opportunity to be heard, and where a tribunal avails to an individual an opportunity to be heard, and that individual fails to or refuses to appear before it, it cannot be stated that he or she was denied the right to be heard, and the principle in Father Nasensio Begumisa and 3 others versus Eric Tiberanga, Supreme Court Civil Appeal number 17 of 2004, Kampala Law Reports, page 236, that where the plaintiff appears and the defendant does not appear when the suit is called on for hearing, if the court is satisfied with the summons or notice of hearing was duly served, it may proceed ex parte. The committee found, as a matter of fact, Honorable Namganza was duly served with the letters inviting her to appear before the committee, together with the schedule of the meetings, and the evidence was adduced before the evidence that was adduced before the committee. Therefore, the committee resolved to proceed with the matter ex parte. The committee, being cognizant of the fact that the burden of proof lay with the mover of the motion, proceeded to scrutinize the prima facie, scrutinize and identify whether there was a prima facie evidence to the allegations in the motion as required by Rule 1099A of the Rules of Procedure of Parliament. 7. Consideration and of the admissibility of the evidence adduced by the witnesses. As earlier noted, the committee received various pieces of oral, documentary, and electronic evidence from the witnesses in support of the motion. The committee, being mindful of its mandate to scrutinize and identify prima facie evidence to prove the allegations contained in the motion, scrutinize the evidence having regard to the rules of evidence in the Evidence Act, Chapter 6 of the Laws of Uganda, and decided cases. Accordingly, the committee subjected the evidence to the principle of relevance and admissibility. The committee also considered the authenticity of the evidence adduced by the witness, and since the authenticity and genuineness of evidence is a condition antecedent to its admissibility. 7.1 Admissibility of evidence adduced by Honorable Court Amos. The committee scrutinized the evidence adduced by Honorable Court Amos in support of the motion with a view of establishing whether it was relevant and admissible as noted here under. The report of the Standing Committee on Rules, Privileges and Discipline in the inquiry into the allegations of misconduct and misbehavior against Honorable Namganza Princess MP Bukono County and Minister for State Housing and Urban Development, and appendices there too. The transcripts of the proceedings of the committee and minutes of the meeting of the committee. This is the evidence he produced. The above documentary evidence was admitted since it relates to evidence of parliamentary proceedings which, upon being laid in Parliament and adopted, become public documents which are admissible under Section 79 of the Evidence Act. Printouts of the WhatsApp messages allegedly posted by Honorable Namganza on the official WhatsApp group of the 11th Parliament, namely 11th Parliament official. If you can put a printout of those messages on the screen, respectively. Printouts were admitted. No, that is a newspaper. There are printouts of the WhatsApp messages. The printouts were admitted in evidence since they were part of the documents annexed to the report of the Committee on the Rules, Privileges and Discipline on the inquiry into the allegations of misconduct and misbehavior against Honorable Namganza, and the authenticity of the evidence was verified by the witnesses who appeared, who are members of the WhatsApp group and the admins of the WhatsApp group, as indicated at pages 14, 21, 24, 25 of the report of the Committee on Rules, Privileges and Discipline. C. Daily Monitor online newspaper of 22nd May, you can project it, of 22nd May 2022 with the heading Parliament has no power to suspend me, Namuganza. The committee noted that whereas newspapers are generally not admissible in evidence since they are considered to be hearsay, the evidence was admitted as it was considered relevant to the allegations into the inquiry within the meaning of Section 4 of the Evidence Act. In addition, the evidence was verified by the Committee on Rules, Privileges and Discipline through the submission of Julian Mwine, the head of the news at NTV Uganda, who stated that the interview was conducted by NTV, that is the article, was conducted by NTV reporters at Parliament and aired on NTV Kusawemu and NTV Weekend Edition bulletins respectively on Friday 21st May 2022, and provided a link from which the said interview could be downloaded. Based on the submission, the Committee on Rules, Privileges and Discipline concluded that the statements which were quoted in the Daily Monitor newspaper of 22nd May 2022 were reproduced from the interview Honorable Namuganza held with NTV Uganda, aired on NTV Friday 21st May 2022. Furthermore, the Select Committee wrote to the Managing Director of NTV Uganda requesting him to authenticate the video recordings of the interview Honorable Namuganza held with NTV Uganda on 21st May 2022, among other recordings that the witnesses had adduced in evidence. In response, Julian Mwine, the head of news at NTV, via emails dated 17th and 18th January 2023, forwarded a link from which the video could be downloaded, Appendix 31, which further confirmed the authenticity of the newspaper article. Video recording of the interview Honorable Namuganza held with NTV Uganda, which aired on NTV Kusawemu and NTV Weekend Edition bulletins respectively. Kindly play the videos. Sound.
Chairman, please continue. Once they get ready with the sound, they will alert me, and then you play.
The committee considered the video recordings of the interview, which aired on NTV Weekend Edition bulletins, admissible since its authenticity was verified by the Committee on Rules, Privileges and Discipline through the submission of Mrs. Julian Mwine, the head of NTV News and at NTV Uganda, to the Committee on Rules, Privileges and Discipline, who confirmed that the committee that the interview was conducted by NTV reporters at Parliament and aired on NTV Weekend Edition bulletins on Friday 21st May 2022. In addition, Ms. Julian Mwine confirmed to the Select Committee via emails dated 17th and 18th January 2023 above that the stories were aired by NTV on 21st May 2022 and provided a link from which they could be downloaded. However, the committee did not admit the evidence of the video recordings of the interview which aired on NTV Kusawemu, since this was not in English. Since this was not in English language as required by Article 6 of the Constitution of Uganda and Rule 4 of the Rules of Procedure of Parliament, and a translation thereof was not provided to the committee by the mover of the motion. Video recordings of the interview Honorable Namuganza held with NBS on 9th December 2022. Is the sound clear? Whereas the committee found the above evidence relevant to the facts in issue since it relates to the conduct of Honorable Namuganza following consideration of the report of the Committee on Rules, Privileges and Discipline, on which the grounds for the motion were pegged, the authenticity of the video recording could not be verified by the time of writing this report. Accordingly, the committee did not admit the evidence. Video recordings of the past conduct of Honorable Namuganza picked from the various media houses. The committee noted that the above evidence was beyond the scope of the allegations contained in the motion and the supporting documents, and admitting it in evidence will be ultra-vires its mandate under Rule 1099 of the Rules of Procedure. The dates was clearly stated in the motion, therefore providing any other video that appeared on another day will be ultra vires. Secondly, the committee could not verify the evidence since it comprised of a compilation of by the witnesses of video clips picked from various media houses, and the committee could not establish the subject matter in relation to which the clips related. The committee notes that since video clips by nature are susceptible to manipulation and alteration, they must be verified for them to be relied upon in evidence, and these are usually produced by the person who broadcast them. Just like newspapers, otherwise they would fall under the classification of hearsay evidence, which is inadmissible. The court in Olega vs. Alidriga, Civil Appeal number 6 of 2013, found that video recordings, a video recording is regarded in law as a document, and being a document like any other document being offered in evidence, a recording must be authenticated by a witness must offer evidence establishing that the object is what the witness claims it to be. In view of the above, the committee considered the evidence inadmissible and disregarded it, because it was the burden of proof was with the movers. If they couldn't verify the source, there's no way the committee would admit it as required by law. Admissibility of evidence adduced by Honorable Tuishire Dan. The committee scrutinized the evidence adduced by Honorable Tuishire Dan as follows. Daily Monitor newspaper, 22nd May 2022, with the heading "Parliament has no powers, suspend me." The same newspaper article was adduced as evidence by Honorable Court John Amos and was admitted in evidence as indicated above. A photocopy of an article of the Daily Monitor, Monday 23rd May 2022, titled "Parliament Committees are like torture chambers," says Namuganza. The committee wrote to the managing director of the Daily Monitor newspaper attaching a copy of the newspaper article and requesting for authentication of the same. In response, the Daily Monitor returned to the committee a certified copy of the newspaper article. Accordingly, the newspaper article was admitted in evidence. C. Various video recordings entitled "Fake Report," wherein Honorable Namuganza appears to be responding to the report of a committee of parliament in the English language. The committee noted that the video recording entitled "Fake Report" comprised of a video clip from an interview Honorable Namuganza held with NTV Uganda, which aired on NTV Weekend Edition Bulletin on Friday 21st May 2022, which, as noted earlier, the committee admitted the evidence while considering the evidence of Honorable Court. Ignorant Parliament, wherein Honorable Namuganza allegedly referred to Parliament as not sober. Similarly, the committee admitted the video evidence entitled "Ignorant Parliament" as it comprised of a video clip from the interview Honorable Namuganza held with NTV Uganda, which aired on NTV Weekend Edition Bulletin on Friday 21st May 2022. As earlier noted, the committee admitted in evidence while considering the evidence of Honorable Court. Minister refuses to apologize, wherein Honorable Namuganza allegedly refused to apologize to the House following her indictment for misconduct and misbehavior by the report of the Committee on the Rules, Privileges and Discipline. The committee admitted the video evidence entitled "Minister Refuses to Apologize." The committee confirmed the contents of the video recordings through the Hansard of the plenary proceedings of the Wednesday, 7th December 2022, wherein it established that during the consideration of the report of the Committee on Rules, Privileges and Discipline on the inquiry into the allegations of misconduct and misbehavior against Honorable Namuganza, Honorable Namuganza was requested to apologize, but she declined. The evidence was therefore admitted in line with the principle in the case of Olega versus Alidriga, since the committee could verify the contents of the video through the parliamentary Hansard. Honorable Namuganza storms out of rules, play video in the House, where Honorable Namuganza appears to be speaking in what appears to be a meeting of a committee of parliament, where after she allegedly stormed out, the committee confirmed the contents of the video recording entitled "Minister Namuganza Storms Out of the Rules," using the transcript of the proceedings of the Committee on Rules, Privileges and Discipline on Wednesday 14th September 2022 at page 31 and at page 6 of the minutes of the committee, where it laid together with the report of the committee in the House, which, as noted earlier, forms part of the record of the House and is admissible in evidence as a public document within the meaning of sections 73 and 79 of the Evidence Act. 5. Even dogs fall in love. Why Honorable Namuganza allegedly insulted the person of the Right Honorable Speaker of Parliament by comparing her marriage to that of dogs. The committee could not establish the source and authenticity of the video recording since its source was not disclosed, and besides, the video recording was not translated in the English language as required by Article 6 of the Constitution of Uganda and Rule 4.
Procedure, Honorable Secretary.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, on the 29th of September, we had elections of members of Yara, and we set a precedent to allow members that had big commitments to vote and go attend to other commitments. With your indulgence, wouldn't it be procedural right to allow us to do this such that members that have other appointments can move? I beg to move.
Thank you.
Because we have so many members that we can't fit here.
Thank you.
500. Thank you.
Thank you. Honorable colleagues. Honorable colleagues. Please, just let's listen, okay? You have come to conduct business. And the smartest way is to follow the procedure very well. Now, the rule 109 is very, very clear on the procedure. Now, the procedure we are on is the committee presenting a report. After presenting a report, in reference to what the Honorable Semuju had raised earlier, Rule 109, Sub-Rule 12, requires us that we open a debate with the mover of the motion. Article 118, Clause 6, is very clear of the Constitution that after the person who is being accused is given a chance to be heard. Now, how do you start voting before all this is accomplished? But number two, what are you voting on? But number three, you see, Rule 98 is totally different from Rule 99. And I emphasized it at the beginning. Rule 98 to do with secret voting is totally different from Rule 99, which is to do with roll call, whereby we shall first require, I think, to even one member may be moving that we suspend Rule 99, I think Sub-Rule 6, which requires that we shall call all of you inside, we close doors. Yes. So these are your rules, members. I'm just implementing your own rules. So I'm not reinventing anything. So let us continue. The chairman is about finished from the size of the report I'm seeing. And then we open a debate. We give Honorable Namgans a chance to be heard. And then we put a question and we start voting. Okay? Procedure, Honorable Sarira. But let's now not take more of our minutes, colleagues.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, this matter we are dealing with can potentially lead to litigation. So we must be very careful, especially when it comes to our rules of procedure. Right Honourable Speaker, it is my humble submission that all the documents being referred to in the report be laid on the table for record purposes, all of them, so that you don't leave any loophole. Right Honourable Speaker, if we don't do that, we are likely to have many challenges. So procedurally, Right Honourable Speaker, I seek your indulgence that whatever information that the chair is making reference to in terms of annexures, in terms of videos, whatever, should be laid and captured by the record.
Thank you. Honorable colleague, that's what the chairperson started with. But clerk, for purposes of scrutiny, kindly ensure that you check that we have. But also, colleagues, you check on the attached document. We should be having all these documents. Okay? So, Chairman, proceed as we come to the conclusion.
Video recording of, sorry, I was on 5. Even dogs fall in love. Why in it's a repetition. Video recording of the interview Honorable Namganza and Baba Television held on 13th December 2022. The committee viewed the video recording of the interview Honorable Namganza held with Baba Television on 13th December 2022 and noted that the video was recorded in both English and Luganda. The video recording was not translated in the English language as required by Article 6 of the Constitution of Uganda and Rule 4 of the Rules of Procedure of Parliament, which said that all our proceedings must be in the English language. Accordingly, the committee did not admit the video recording in evidence. Right Honorable Speaker, I beg your indulgence. It seems they have sorted the video.
If you're ready with the videos, you can play. Please, Chairman, proceed. Only call on me if you're ready, okay? Chairman, proceed.
Evidence adduced by Honorable Saro Pendi. Honorable Saro Pendi adduced evidence of the Hansard of the plenary proceedings of Wednesday, 13th July 2022 in support of her assertion that the matter of the alleged misconduct and misbehavior was raised in the House by Honorable Solomon Silwani on 13th July 2022 before the marriage of the Right Honorable Speaker took place, and therefore the issues allegedly surrounding the marriage could not be the cause of the censor proceedings. The committee observes that whereas the matter of the marriage of the Right Honorable Speaker is not an issue, it was relevant to the facts in issue for the purpose of clarifying that the censor proceedings were not motivated by a personal grudge. As alleged, accordingly, the committee admitted the evidence of the Hansard of the plenary proceedings of 13th July 2022, which is a public document and forms part of the record of the House. Evidence adduced by Honorable Solomon Silwani. Honorable Solomon Silwani adduced electronic evidence in form of video recordings in support of his assertion that Honorable Namganza was in the habit of attacking fellow leaders and had on several occasions attacked the former Speaker of Parliament, the Right Honorable Rebecca Kadaga, as follows. A video recording entitled Clip 1, which appears to be a news broadcast by NTV Uganda in Luganda, wherein Honorable Namganza allegedly described the report of the Committee on Rules, Privileges and Discipline as biased and accused the Right Honorable Rebecca Kadaga of influencing the findings in the report. A video recording entitled Namganza Attacks Kadaga in the 10th Parliament, which appears to be a news broadcast of NBS in Luganda relating to an investigation into the conduct of Honorable Namganza by the Busoga Parliamentary Caucus during the 10th Parliament. The committee noted as follows: that in the two evidence adduced by Honorable Silwan relate to matters that are not contained in the scope of the allegations in the motion, and the supporting documents admitting videos in evidence will be ultra-vires the mandate and powers of the committee as prescribed under 1099 of the Rules of Procedure. The videos Honorable Solomon Silwani submitted happened at a later date, and whereas the mover specified the exact dates in his motion. The videos were not recorded in the English language, and the translation of the recordings was not provided. It was the duty of the movers and seconders to go to Makerere and have these translated before the committee can look at these documents, these videos. The committee observes that the principle of admissibility of electronic evidence in the case of Elegavas Alidriga above is in that the party offering the recording has to produce a transcript of the recording which accurately reflects the recording's content, since evidence in all courts has to be recorded in English as the official language of court, and if the recording is in any other language, the transcript of that recording should be translated into English before it can be received in evidence. The videos also refer to draft reports of the Parliamentary Committee on Rules, Privileges and Discipline, which was directed on 15th March 2018 during the 10th Parliament to investigate the conduct of Honorable Namuganza following a complaint raised by Honorable Abala David, the Member of Parliament for Ngora County, who had complained about various utterances by Honorable Persis Namuganza against the then Speaker of Parliament. Whereas this matter was referred to the Committee on Rules to investigate, by that time the 10th Parliament was prologued. The report had not been considered by the House, and no resolutions were made on the matter. Since the report was not considered by the 10th Parliament, it lapsed as required in Rule 235 of the Rules of Procedure of Parliament, a matter the then Speaker of Parliament guided upon on the 16th September 2021. This means that the report on the Rules Committee of the 10th Parliament relating to the investigation of Honorable Namuganza has no evidential value in this matter, since the report was never considered by the House and lapsed with the 10th Parliament. It is important to note that a committee report becomes actionable when it is adopted by the House. Committee minutes, reports and recordings become accessible to the public when they become part of the record of Parliament. Indeed, in court in Spear Motors versus the Attorney General and two others, High Court Civil Suit number 0692 of 2007 held that once a signed report is laid on the table, it becomes a record of the House. The debate and adoption of the report are two other separate matters. And whether or not the report of a Committee of Parliament is adopted or seems to be relevant to its becoming a record of Parliament, the principle in this case is that once a report of Parliament is laid on table, it becomes part of the record of the House and is actionable once it is adopted by the House. Therefore, since the report on the Rules, Privileges and Discipline of Committee of the 10th Parliament on the alleged misconduct of Honorable Namuganza was not laid on table in the Parliament, it does not form part of the record of the House, and further no action can be taken, and the same since it was never adopted by the House then. In the same vein, the committee could not admit the video recordings of an investigation of the Busoga Parliamentary Caucus, since such investigation was not conducted by an organ of Parliament, nor a report thereof tabled in Parliament for its consideration. This therefore means that the report of the investigation by the Busoga Parliamentary Group does not form part of the record of the House. Thirdly, the report is also beyond the scope of the committee's investigation, since it happened in the 10th Parliament, and the mover specified the dates in his motion. For the above reasons, the video recordings adduced by Honorable Silwani were not admitted in evidence. Upon determining the admissibility of the evidence, the committee resolved that it would consider only the evidence it admitted to resolve the issue of whether there was a prima facie evidence to prove the allegations in the motion. Findings and observations determining the issues, whether a prima facie evidence has been adduced to prove the allegations contained in the motion of censure against Honorable Namuganza Princess, State Minister for Lands, Housing and Urban Development, upon satisfying itself on the legality of the grounds set out in the motion and supporting documents and identifying admissible evidence. Now we are going to consider only the evidence we admitted and try to see whether it has a prima facie case establishes. The committee proceeded to examine whether the evidence adduced in support of the motion discloses a prima facie case against Honorable Namuganza. In resolving the above issue, the committee deemed it prudent to examine the definition of the term prima facie and the standard of proof required to establish a prima facie case under the laws of Uganda and case law. The committee noted that whereas the term prima facie is not determined under the rules of procedure of Parliament nor any other laws in Uganda, it has been defined by courts in several cases, including the case of Rananlal T. Bhatt versus Republic, East African Law Reports 332, which stated that a prima facie case is established when the evidence adduced is such that a reasonable tribunal properly directing its mind on the law and evidence would convict the accused person if no evidence or explanation was set out by the defense. Furthermore, in the cases of Semambo and another versus Uganda, criminal application number 76 of 1998, Court of Appeal, court held that a prima facie case means a case sufficient to call for an answer from the accused person. According to the decision of Rananlal T. Bhatt and Republic and Semambo above, the evidence required to establish a prima facie case is such evidence that sufficiently establishes a fact in absence of evidence to the contrary, but is not conclusive. Therefore, what the court has to decide is at the close of the prosecution case is whether a case has been made out against the accused just sufficiently to require him to make his or her defense. Using a simple example, this is like saying a burglar accessed your premises without authority with the intent to commit burglary and actually stole. That's what a prima facie case would mean. In light of the above, the committee resolved that a prima facie case shall be made out where evidence adduced by the movers of the motion or any other person appearing to support the motion proves the allegations contained in the motion and supporting documents, and the evidence has not been discredited or rebutted by the accused minister or any other person appearing to defend the minister. In the same vein, the committee observes that a prima facie case shall not be made out if no evidence adduced to prove the allegations contained in the motion and documents supporting the motion, or if the evidence adduced in support of the motion has been discredited as a result of cross-examination arising from the evidence adduced to the committee in defense of Honorable Namuganza, or if the evidence in support of the censor is unreliable, that no reasonable court or tribunal could safely convict Honorable Namuganza basing on the evidence. The committee is also guided by the principle Civil Appeal number 119 of 2008, Odongo Chama Hussein versus Abdul Rajab, wherein court observed that the evaluation of evidence to determine a prima facie case must be approached as a whole. The court ought not to consider the plaintiff's story in isolation of the defendant's story, and finally decide which of the two to prefer. The evidence must be considered on each contentious point in the trial, in the absence of probabilities, for the correct decision to be made. The principle in this decision is that the committee should consider the evidence as a whole, and each contentious matter must be specifically addressed before the committee makes a determination. The committee notes that whereas Honorable Namuganza did not adduce any evidence in her defense, it was duty-bound to evaluate the evidence adduced by the mover and any other person who appeared before it to determine whether a prima facie case has been established. Accordingly, the committee evaluated the evidence and established whether it provided the allegations in the motion. Allegation 1. Following the resolution of Parliament on the report of the ad hoc committee on the Naguru Nakawa land allocations, Honorable Persis Namuganza Princess on 21st and 22nd May, and again on 12th and 13th July 2022, made statements about Parliament in the media and on social media, attacking the operations of Parliament, questioning the powers of Parliament, the integrity of the presiding officers of Parliament, and imputing improper motives to Parliament and its presiding officers. The Select Committee examined the evidence adduced and finds that the following evidence supports the above allegations. Printouts of WhatsApp messages posted by Honorable Namuganza on the 11th Parliament official WhatsApp group. The committee examined the following statements made by Honorable Namuganza on the WhatsApp group of the 11th Parliament official using her telephone number 0782670551. I quote, I remember people accusing me on this, the so-called ad hoc committee, in a spirit of abusing, hating, embarrassing, tarnishing each other's name. As colleagues can't take us anywhere. We need to build consensus and friendship. Shame. So why then does he appoint ministers? That strategic matters. You call Naguru land also a strategic matter? Maybe you don't know what strategic matters mean. What I'm emphasizing, colleagues, is that it is very bad to just be used to fight each other. We still have a long way to go, even life after Parliament. You need to study a matter yourself and decide without being misled and influenced to fight a colleague. I am telling you, the powerful committee couldn't even find time to go and interact with HE himself. Why? So, for now, you can go and ask him whether Honorable Minister has initiated this call. He is there alive, so kindly go for avoidance of doubt. And these so-called ad hoc committees all the time. We have substantive committees of Parliament. They should be the ones to handle matters that follow under their responsibilities. Why ad hoc? As if they are hired to embarrass. Anyway, the matter is in court for judicial interpretation. So what will the substantive committees do? All this is done in bad faith. You can continue to defend it the way you want because you are a member, but this must stop. It should stop. All members of parliament came to work and they belong to these parliamentary committees. We shall raise a point of order, if another ad hoc committee is formed to create order in the House. Like the one which is investigating the importation of rice. It's supposed to be the Committee on Trade. Why ad hoc for a few members? Where there exists a sectoral or standing committee in which a matter to be investigated falls squarely within the parameters of that sectoral or standing committee, it is specific. It is that specific committee to handle or investigate it. And where there exists none is when such an ad hoc committee shall be constituted. The continued formation and constitution of ad hoc committees for whatever intent and purpose they are constituted or formed in total disregard of the rules is utter breach, violation, and to say the least, acting ultra vires in contravention of the rules of procedure we ourselves adopted. That's Honorable Namuganza's WhatsApp message on the official group. The Select Committee found that the statements contained in the printouts were the same as those laid before the Committee on Rules, Privileges and Discipline and attached to its report to the House, and the same statements Honorable Court Amos based upon to move the motion for the censure of Honorable Namuganza as indicated on pages 1-2 of the notice of motion to the clerk to Parliament, which is part of the document supporting the motion. The committee is therefore satisfied that Honorable Namuganza made the statements on social media, bashing operations of Parliament and questioning the powers and integrity of the House to appoint ad hoc committees as provided under Rule 191 of the Rules of Procedure of Parliament, which says that the House may at any time, on the advice of the Business Committee, appoint an ad hoc committee to investigate any matter of public interest that does not come under the jurisdiction or any standing or sectoral committee, or that has been dealt with by a select committee. B. Evidence of the newspaper article published in the Daily Monitor of 22nd May 2022 with the heading Parliament has no power to suspend me, Namuganza. The committee examined the newspaper article published in the Daily Monitor on 22nd May 2022 to determine whether Honorable Namuganza made the statements alleged in the motion. The committee found that Honorable Namuganza made the following statements in the newspaper article. But you saw what happened. It was like mob justice. Moreover, in Parliament, they did not want me to speak. They did not even want me to cite that the letter is missing. So this report was misleading members of Parliament, debating things which they do not know and passing a resolution on something they do not actually know. But on this basis of a fake report full of bias, then you tell me to step aside. First of all, I belong to the executive, and I think they will or have forwarded this to the executive. I am sure the executive is sober and does not act the way they did. Based on the above evidence, the committee finds that the evidence proves the allegations contained in the motion and meets the standard of proof required to establish a prima facie case envisaged under Rule 1099A of the Rules of Procedure of Parliament. C. Evidence of the video recordings of the interview Namuganza held with the NTV Uganda on 21st May 2022. The committee examined the video recordings of the interview Honorable Namuganza held with NTV on 21st May 2022 and established that she made statements attributed to her in the interview, and the same statements are those that were reproduced in the Daily Monitor newspaper article of 22nd May 2022, which the committee has already examined herein above. In consideration of the statements made in the said interview, of the committee found Honorable Namuganza attacked the operations of Parliament, questioned the powers of Parliament, the integrity of the presiding officers of Parliament, and imputed improper motives on members of Parliament and the presiding officers of Parliament, contrary to the Constitution and the Rules of Procedure of Parliament. The committee is therefore convinced that a reasonable tribunal properly directing its mind on the law and evidence would find Honorable Namuganza to have made statements in the motion, and that the supporting documents based on the evidence on record. Based on the above, the committee finds that the evidence proves allegations contained in the motion and meets the standard of proof required to establish a prima facie case envisaged under Rule 1099A of the Rules of Procedure of Parliament. Allegation 2, that the statements made by Honorable Namuganza Princess were derogatory and were found by Parliament to amount to gross misconduct and misbehavior, an affront to the dignity of Parliament, denigrated public trust and confidence in the authority and integrity of the office of the Speaker, members of Parliament and the institution of Parliament, and brought the House and its members into disrepute, and her conduct was in breach of the Code of Conduct for Members of Parliament as enumerated in Appendix F of the Rules of Procedure of Parliament, paragraphs 2, 3, 4, and 5 constituted contempt of Parliament. In proving the above allegations, the committee relied on the following evidence. Printout of WhatsApp messages posted by Honorable Namganza on the 11th Parliament WhatsApp official group. The committee examined the statements posted by Honorable Namganza on the 11th Parliament official WhatsApp group as highlighted earlier in this report. That ad hoc committees are instituted in bad faith, they are used to fight people, and they are hired to embarrass. They are being misled and influenced, and they are created for a few members, and finds them to be derogatory. They imputed improper motives on Parliament and denigrated public trust and confidence in the authority and integrity of Parliament, the presiding officers and members of Parliament in the institution of Parliament as a whole. B. Evidence in the newspaper article published in the Daily Monitor of 22nd May 2022 with the heading, Parliament has no power to suspend me Namganza. The committee finds that the statements made by Honorable Namganza in reference to the report of the ad hoc committee on Naguru Nakawa land allocations as quoted in the article in the Daily Monitor newspaper, that the report was misleading members of Parliament. They were debating things which they do not know, passing a resolution on something they do not actually know, and that she would not resign on the basis of a fake report full of bias, and the influence of Parliament was not sober, and that Parliament was not sober, were derogatory, and they belittled Parliament and undermined its authority. They were an affront to the dignity of Parliament. C. Report of the Standing Committee on Rules, Privileges, Discipline on the inquiry into the allegations of misconduct and misbehavior.
Right on.
Is that someone on Zoom? Yeah, please, we can play the videos at the end. Let him finish, and then at the end we play the video. Okay? Thank you.
Report of the Standing Committee on Rules, Privileges. The Select Committee has found as a matter of fact that Parliament found that by attacking the impugned statements, the conduct of Honorable Namganza amounted to gross misconduct and misbehavior and was an affront to the dignity of Parliament. It denigrated public trust and confidence in the authority and integrity of the office of the Speaker, members, and the institution of Parliament, and brought the House and its members into disrepute. Her conduct was in breach of the Code of Conduct for Members of Parliament as stipulated in Appendix F of the Rules of Procedure, contempt of the Rules of Procedure of Parliament, specifically paragraph 2, 3, 4, and 5, and constituted contempt of Parliament as noted at page 39 of the report of the Committee on Rules, Privileges and Discipline, which was adopted by Parliament on Wednesday, 7th December 2022. Therefore, the finding and recommendation contained in the report form part of the resolutions of Parliament. Accordingly, the committee finds that evidence on record proves allegations 2, and the evidence meets the standard of a prima facie evidence required under Rule 1099 of the Rules of Procedure of Parliament. Allegation 3, the conduct and behavior of Honorable Persis Namganza amounts to misbehavior or misconduct under Article 118, 1B of the Constitution. The committee evaluated the evidence adduced by the witnesses to determine whether there is a prima facie case established on the grounds of misbehavior or misconduct under Article 118 of the Constitution. The committee examined the meaning of the words misbehavior and misconduct and established that the words are not defined under the laws of Uganda. The committee therefore had recourse to the dictionary meaning of the words. According to the Black's Law Dictionary, 6th edition, misconduct is defined as a transgression of some established and definite rule of action, a forbidden act, dereliction from duty, unlawful behavior, willful in character, improper or wrong behavior. Its synonyms are misdemeanor, misdeed, misbehavior, delinquency, impropriety, mismanagement, offense, but not negligence or carelessness. This definition was adopted in the definition of the court decision in the case of Foxodoi or Owelo. And another versus the Attorney General Constitutional Petition number 8 of 2003, which found that misconduct connotes willful transgression of some established and definite rule of action. On the other hand, misbehavior is defined in the Black's Law Dictionary 4th edition as ill conduct, improper and unlawful behavior. In view of the above definition, the move of the censor motion had to adduce evidence to show that the conduct of Honorable Namuganza was a transgression of some established and definite rule of action, a forbidden act, a dereliction from duty, unlawful behavior, willful in character, improper or wrong behavior. The committee notes that the standard of behavior and conduct expected of members of parliament, including ministers, is prescribed in the rules of procedure of parliament. The committee is of the considered opinion that the standard of behavior and conduct expected of members of parliament to all members of parliament, irrespective of whether they are elected members or ex-officio members, the principle that members of parliament are equal before the law was examined in the court case of Brigadier Tumukunde versus Attorney General and another Supreme Court Constitutional Appeal number 2 of 2006, wherein court held that we agree that soldier members of parliament are full members of parliament with equal rights and obligations as the civilian members of parliament. They subscribe to an oath of office to defend, support, and uphold the Constitution at all times. It is not disputed that the petitioner is entitled to all the powers and privileges any member of parliament has. Rule 85 of the Rules of Procedure of Parliament provides that the behavior of a member shall be guided by the Code of Conduct of Members of Parliament prescribed in Appendix F. The Code of Conduct of Members of Parliament under Appendix F of the Rules of Procedure prescribes the standard of behavior expected of members of Parliament. The code is designed to assist the members in the discharge of their obligations to the House, their constituents, and the public at large. Paragraph 2 of Appendix F of the Rules of Procedure of Parliament, which places the public duty of members to uphold the law and act on all occasions in accordance with the public trust placed in them. Paragraph 3 of the Code of Conduct, which elaborates that the general principle of conduct expected of members of Parliament, wherein members are required to observe the principle of selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. Paragraph 5 of Appendix F of the Rules of Procedure of Parliament requires members of Parliament to conduct themselves in a manner which will maintain and strengthen the public trust and confidence in the integrity of Parliament, and never undertake any action which may bring the House or its members generally into disrepute. In the case of Saverino Twinob Sinjan versus Attorney General, Constitutional Petition number 47 of 2011, the Constitutional Court pronounced itself on the conduct expected of members of Parliament at pages 24 and 25. It stated, "We hasten to observe in this regard that although members of Parliament are independent and have the freedom to say anything on the floor of the House, they are, however, obliged to exercise and enjoy their powers and privileges with restraint and decorum, and in a manner that gives honor and admiration not only to the institution of Parliament, but also to those who inter alia elected them, those who listen to and watch them debating in the public gallery and on television, and read about them in the print media. As the national legislature, Parliament is the fountain of constitutionalism, and therefore the honorable members of Parliament are enjoined by virtue of their office to observe and adhere to the basic tenets of the Constitution in their deliberations and actions." Having established that the standard of conduct and behavior expected of members of Parliament, ministers inclusive, the committee proceeded to examine whether the evidence adduced by the witnesses established a prima facie case of misconduct or misbehavior under Article 118 of the Constitution. In so doing, the committee examined the actions complained to determine whether the conduct and behavior of Honorable Namuganza contravene the standard of conduct and behavior expected of members of Parliament prescribed in the Code of Conduct of Members in Appendix F of the Rules of Procedure of Parliament. The committee finds as follows: by making statements on the WhatsApp group of the 11th Parliament official to the effect that ad hoc committees are instituted in bad faith, they are used to fight people, they are hired to embarrass, they are being misled and influenced, and they are created for a few members. Honorable Namuganza failed in her duty at all times to conduct herself in a manner which will maintain and strengthen the public trust and confidence in the integrity of Parliament, and never to undertake any action which may bring the House or its members generally in disrepute, contrary to paragraphs 5 of the Code of Conduct of Members of Parliament. Her conduct fell short of the general principles of conduct of members of Parliament are enjoined to observe as stipulated in paragraph 3 of the Code of Conduct, namely selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. B, by making statements in an interview with NTV held on 21st May 2022, as reproduced in the Daily Monitor newspaper article published on 22nd May 2022, the report of the ad hoc committee on the Nakawa Naguru land allocations was misleading, fake, and biased, and referring to Parliament as comprising of persons who lacked understanding of what they were doing when they were passing the resolutions adopting the report. Honorable Namganza lowered the esteem of Parliament in the eyes of the public, belittled the presiding officers of the House, its members, and consequently the people of Uganda who elected those leaders in line with their constitutional mandate. Her conduct brought Parliament and its members into disrepute and breached paragraph 5 of the Code of Conduct in Appendix 5 of the Rules of Procedure of Parliament. In Appendix 5, Honorable Namganza ought to have used proper channels of challenging the composition of the ad hoc committees as provided for under Rule 87.2 of the Rules of Procedure of Parliament, as opposed to challenging them on social media. C, by referring to Parliament as a torture chamber, as reported in the newspaper article published in the Daily Monitor of Monday, 23rd May 2022, titled "Parliament Committees Are Like Torture Chambers," says Namganza. Honorable Namganza undermined committees of Parliament, which are constitutionally established. She denigrated the integrity of Parliament and its members and lowered the esteem of Parliament in the eyes of the public. In the said newspaper article, Honorable Namganza is quoted to have made the following statements. This is a disgrace. How can investors who are interested in improving our economy be treated like that? The President should rein in. The President should also investigate this torture chamber, referring to Parliament committees. In reference to the findings and recommendations in the report of the Nakawa Naguru land allocation, she stated that when we meet the President, he gives verbal instructions. But when you take the same instructions to the committee, they accuse you of framing the instructions. They should look at other methods of verifying the President's instructions rather than embarrass the messenger. The President is my witness. He knows very well that he gave me the instructions and I was working to fulfill them. Some of these new MPs need more orientation to understand how the system works. Based on the above pieces of evidence,
Chairman, procedure protected.
Based on the above pieces of evidence, the Select Committee finds prima facie evidence confirming that the conduct of Honorable Namganza Princess, Minister for State Lands, Housing and Urban Development, breached the standard of behavior and conduct expected of a Member of Parliament as prescribed in Rule.
So, colleagues, we are left with 4 pages. So let's not interrupt the chairman. Let him conclude.
As prescribed in Rule 85 and Appendix F of the Code of Conduct of Members of Parliament, prescribed in the Rules of Procedure of Parliament, and such conduct amounts to misbehavior or misconduct under Article 1181B of the Constitution of the Republic of Uganda, 1995. The committee therefore finds that the above evidence meets the standard of proof required to establish a prima facie evidence, a prima facie on grounds of misconduct or misbehavior under Article 118 of the Constitution. Before taking leave of this matter, the committee notes with concern the allegations referred by Honorable Sarah Opendi in her submission to the committee, to the effect that Honorable Namganza made allegations in the House and on various media platforms that the censor proceedings against her were initiated to set a personal grudge relating to the legal issues allegedly surrounding the marriage of the Right Honorable Speaker of Parliament, Anita Aneta Mong. For the avoidance of doubt, Honorable Sarah Opendi stated that she was only responding to the allegations that the censor of the Honorable Namganza is as a result of personal matters between the Right Honorable Speaker of Parliament and Honorable Namganza. That on numerous occasions, Honorable Namganza has indicated that the censor motion is brought against her to settle personal grudge relating to the legal issues surrounding the marriage of the Right Honorable Speaker. That the above allegations were not true because the Right Honorable Speaker had not taken any decision or presided over any proceedings involving the reference of the conduct of Honorable Namganza to any committee of Parliament, the consideration of any report relating to Honorable Namganza, or any matter relating to the sense of Honorable Namganza. That the matter leading to the sense of Honorable Namganza were raised by Honorable Silwani during the 7th sitting of the first meeting of the second session of the 11th Parliament held on 13th July 2022, and these sittings were presided over by the Right Honorable Deputy Speaker of Parliament. These matters happened before the wedding of the Right Honorable Speaker, which occurred on 30th and 31st July 2022, at which the wedding she, Honorable Pendi, was the matron and therefore cannot be the cause of her censure motion as alleged by Honorable Namganza. E, that the Right Honorable Speaker has not presided over proceedings related to or dealing with any matter involving the sense of Honorable Namganza, and there is nothing personal or a conflict between the Speaker and Honorable Namganza. Right Honorable Speaker, I beg we play these videos specifically for this matter, then we can go to the other ones at the end. The Baba TV video, and
Are you ready, Clark? Please play the video if you're ready. They seem not to be ready, please. Let's proceed. All videos, are we ready?
no, there's a
The ad hoc committee on Nakawa Naguland saga found Minister Persis Namganza culpable for abuse of office and overstepping her mandate when she directed the Uganda Land Commission to allocate land to some companies and individuals.
It was also observed that Honorable Namganza Persis abused her office and authority by directing URC to allocate land to entities while purporting to be communicating a presidential directive which were non-existent.
Asked about
sometime back, ndowooza walaba akafaananyi ku social media nga Right Honorable Anita Amunga yambadde Western culture wear. We call them esuka za Western. N'akafaananyi ne Honorable Magogo Moses nga bakakasuka ku social media nga bagamba nti ababiri baali beyanjudde nga bakoze obufumbo cultural marriage. A cultural function in Ukedea, in her country home. And we rang a magogo atute ente atano embuzi ana oba n'ebiriyoni zimeka naffe ne tulaba okay ate munange abantu baba beyanjula
Yeah. Now, you see, the language is not a language which we all understand. Okay, so I would. The videos which are in English are all translated, are the ones which should be played. Okay, otherwise it's difficult to capture all this.
Yeah. There's a Right Honorable Speaker, we had included all the videos.
Procedure. I have a procedure matter.
Mr. Speaker, the petition, all the document and evidence were given to the committee to examine on our behalf and come here and tell us if a prima facie had been established. Now the committee is making us listen as if we are also going to do the same thing that they did. The procedural issue I am raising, Mr. Speaker, is whether after evaluating evidence, the committee can come back to Parliament and present the same for re-examination. That's the procedural issue.
Thank you, Honorable Semuju. You see, colleagues, a prima facie case is a case on the surface. The standard of proof, the burden of proof, and the standard of proof for a prima facie case is on the balance of probability. Now, the moment you're presenting such a evidence, okay, you need to explain to the members and they make their own judgment. That is why under Rule 109, Sub-Rule 12, it's very clear that notwithstanding the recommendation of the committee, whether the committee exonerates or it does not exonerate, the House must go on and vote. And the moment the question or the motion is carried, the outcome will be pronounced. Now, this is not a committee that can give a final ruling. That's the burden you have. It's a committee whereby whatever evidence was presented, they weighed and gave opinion. But that opinion, if they feel they need to show members more, convince members more so that members can decide on themselves, on their behalf, then they would have to do it. So that's a problem with when you're establishing a prima facie case. Your ruling cannot be final. This is just a case to answer. So the committee only established a case to answer, and that's why Honorable Namuganza must come back here and defend herself. That's why Okot must come and resubstantiate the case, and yet he has been doing it because the ruling of the committee is not final, as provided for under Rule 109, Sub-Rule 12. So let's proceed.
This week, the ad hoc committee on Nakawa Naguland saga found Minister Persis Namuganza culpable.
Colleagues, please allow me to make this ruling. If really we cannot have well-coordinated videos, I would send our ICT team to training for further training so that we don't get that embarrassment again. We have the evidence very clear on record. Chairman, conclude with your report, and then we proceed with other issues.
The committee observes that whereas the matter of the marriage of the Right Honorable Speaker was not an issue, it was relevant to the facts in issue for the purpose of clarifying that the censor proceedings were not motivated by a personal grudge, as alleged. The committee observes that the sequence of events did not support the alleged existence of the grudge. Whereas the committee did not admit the evidence of the video recordings of the interviews of Honorable Namuganza with NBS on 9th December because NBS did not verify, and Baba Television as a basis of establishing a prima facie case because it was in Luganda, the committee examined the video recordings for the purpose of clarifying on the above contentious issue. The committee has examined the chronological events on the matter as indicated in the table below. Kindly put the table of the report. A table showing events leading to the moving of the censor motion. On 1st March 2022, Parliament constitutes an ad hoc committee to investigate the Nakawa Naguru land allocations. On 18th May 2022, Parliament adopts the report of the ad hoc committee on the Nakawa Naguru land allocations. On the 13th July 2022, Honorable Solomon Silwani raises on a matter of procedure regarding the allegations of misconduct and misbehavior against Honorable Persis Namuganza. On the 13th July 2022, the presiding officer, who was the Right Honorable Deputy Speaker, refers the matter to the Rules Privileges Committee on the alleged minister, Honorable Namuganza Princess, on misconduct and misbehavior. On the 30th and 31st July 2022, Right Honorable Speaker Annette Among gets married to Honorable Engineer Moses Magugu. On 7th December 2022, the Rules and Privileges Committee of Parliament presents a report on the matter referred to it on the 13th July 2022 and found that the conduct on the 30th was a traditional marriage and 31st was the wedding. On 7th December 2022, the Rules and Privileges Committee of Parliament presents a report on the matters referred to it on the 13th July 2022 and found that the conduct and behavior of Honorable Persis Namuganza constituted misconduct and misbehavior and is not befitting of a member of Parliament, more so a minister. The committee recommended that the House invokes Article 118, 1B of the Constitution and Rule 106 of the Rules of Procedure. On 7th December, the House adopted the report of the Committee on Rules, Privileges and Discipline. On 9th December, Honorable Court Amos notified the Clerk of Parliament of his intention to move a motion of censure to censor Honorable Namuganza on grounds of misconduct and misbehavior. On 9th December, Honorable Namuganza appears on NBS television and suggests that her censure is influenced by the Right Honorable Speaker as a result of the alleged matters related to Right Honorable Speaker's marriage, which the husband of Honorable Namuganza allegedly handled. On 13th December 2022, Honorable Namganza appears on Baba Television and suggests that her censor is influenced by the Right Honorable Speaker as a result of the alleged matters related to the Right Honorable Speaker's marriage, which Honorable Namganza's husband allegedly handled. In light of the above, in the above chronological order of events, does not support the claim of the grudge being the cause of the censor motion as alleged by Honorable Namganza in her various interviews. The law only calls us to distinguish facts in terms of their occurrence. This is as follows. There is a 17-day lag between the time Honorable Namganza was sent to the Committee on Rules Privileges on alleged grounds of misconduct and misbehavior, 13th July, and the time the Right Honorable Speaker got married on 30th July and 31st July. 2. No new grounds were introduced following the Right Honorable Speaker's marriage. 3. The committee did not establish any single footprint of the Right Honorable Speaker's involvement in sending the Honorable Minister to the Rules and Privileges Committee on allegations of misconduct and misbehavior on the 13th July 2022, where she was not even the presiding officer of the House as established from the Hansard, which was submitted by Honorable Saro Pendi and verified by the committee. D. It is practically impossible that the marriage of the Right Honorable Speaker could have influenced decisions of the committee and the House that were taken prior to its occurrence. E. That the media interviews and statements made by Honorable Persis Namganza Princess attacking the integrity of Parliament, its proceedings and resolutions were made outside Parliament and therefore not privileged, and she has no immunity derived from them. These amounted to contempt of Parliament. In conclusion, the matter raised in the interviews was obnoxious, reckless, insufferable, beyond the pale, and in per incuriam, it was an attack on the person of the Speaker, the Parliament without due regard to the rules of procedure, the protected status, the protected redress, the applicability of evidence, and the decorum of Parliament. In conclusion, the committee, having found prima facie evidence to prove the allegations contained in the motion and supporting documents, prays that this report be adopted by the House and leads the House under Rule 109B of the Rules of Procedure of Parliament in the proceedings of censure against Honorable Namganza Princess from the Office of the Minister for State, Lands, Housing and Urban Development. Right Honorable Speaker, I beg to move.
Thank you. Thank you, Chairman. Colleagues, without further ado, we are going to debate the issue, the report, but this debate will not take long. This debate will not take long because, you see, the rules, they still give you your own authority to come and, you know, make your own decision. So, as per Rule 109, Sub-Rule 12, colleagues, please, the presiding officer is speaking. The presiding officer is speaking. Okay? So, colleagues, let's listen to one another. So, we are going to have a short debate. I'll pick around 6 people. Yes, I'll pick around 6 people on the debate so that we close it. By around 12:30, 12:40, we should start voting on this matter. Then we go to other matters. So, colleagues, Rule 109, Sub-Rule 12 requires that the first person to open the debate is the move of the motion. So, Honorable Amos Okot.
Thank you. Thank you so much, Mr. Speaker and honorable members of Parliament. Mr. Speaker, allow me to thank the Select Committee for the very good report they have produced. Honorable members, you have received the report from the Select Committee on the censure of Honorable Festus Namuganza Princess, State Minister for Lands, Housing and Urban Development. And it has found evidence that Honorable Namuganza conducted herself in a manner unbecoming of a minister, and has found that such conduct amounts to misbehavior and misconduct under Articles 1181B of the Constitutions. Honorable members, the decision to censure a minister is not a decision that should be taken lightly. It has a far-reaching consequences on the minister, his or her family, cabinet, the appointing authority, and the country at large. This explains why the Constitution deemed it necessary that ministers should be censored on a prescribed grounds on members. The evidence was adduced and found to be true. 1, she has been attacking the powers of Parliament as demonstrated, and the evidence that we've adduced before the select committee. And if the clips was to be played, you are going to see it by yourself, the way she belittled, demeaned the integrity of this house. 2, by attacking leaders and members of the house as people who have overthrown the constitutions. If I'm to pause there a bit, it is like on the day she alleged the Right Honorable Speaker has overthrown the Constitution, it is like the government has failed. That was what she did to the public. She lowered the esteem of Parliament of the Republic of this country, that is Uganda. Number 3, honorable members, publicly she has attacked the personalities of both the Speaker, the Deputy Speaker, the honorable members of this House, plus many other things that you have been going through. The Select Committee has found this. If I'm to conclude the way members are trying to push it, let me conclude by saying this. Mr. Speaker, it is our duty. We are the family. We are belonging to this and we have the mandate. It is our duty to correct one another. It is our duty to reprove one another. It is our duty to make sure that the instructions of righteousness is done. And this goes deep to those who believe in Christianity. Even the Bible gives us that power. If one of us, a member of the family, like one of us in these institutions, is doing something which is not right, it is our duty to bring this person to correction and to order. Especially things that goes through our behaviors and the conduct. Our conduct speaks volume. The word that we speak will remain even on the stones, even on the trees, even on the grounds. Those words, you will never ever dispute it unless we bring the reproof and correction to one another. Finally, Mr. Speaker, humility is one thing that we cannot run away from unless we are humble. Unless we are humble, and even that is a God commands, we should be humble to one another. We should submit. It is very sinful if you have been summoned to appear and speak on a subject matters, even though those things are not true. By you appearing, that tells and speaks that this person is humble. Our sisters has been so arrogant. I request this house. My prayers now, honorable members, you are not excluded. This thing calls all of us. Let us stand as one family. Let us protect this. People normally say Parliament is a barking dog. You don't do what? Please, we are here to do the right thing. I want to thank you so much to join hands and to make the image of this institution be strong. I beg to move so that you carry the day. God bless you.
Thank you, Honorable Amos. Colleagues, in line with Article 118, Clause 6, and Rule 109, Sub-Rule 12, I invite Honorable Percy Namuganza to present her case. So with Honorable... please, with Honorable Namuganza being given a chance, which he has not utilized, I also want to confirm if she's not on Zoom. She might be on Zoom. Please, I need you to check. Colleagues, the rules require that before anybody else, we start with the mover, and next should be the minister who is being accused. So I've gotten confirmation from the clerk that she's not online, so she has jumped today's parliamentary proceedings. So I open the debate to other colleagues. I'll start with Honorable Yusuf Mutembri, followed by Honorable Nathan Byanyima. Then I'll pick you, colleagues. Don't mind.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, in accordance with the Rule 109, Sub-Rule 12, I hereby support the motion to the effect that the minister in question must be censored. Right Honorable Speaker, I remember on 23rd of March 2003 at Uganda Christian University, the Vice Chancellor then, Professor Noro, had this to say, that any leader or any professional who does not have integrity, who does not have discipline, and has no respect for others is as good as garbage. I'm quoting the professor. And he emphasized the three things. He was addressing us as students, leaders at that time. He emphasized the three things: that as a leader, you should always have integrity, you must be disciplined, and you must respect others. Right Honorable Speaker, from the report we have just received from the Select Committee, I find my sister short of the three attributes that I've referred to. And therefore, I have nothing much to say other than saying that time is now to bring sanity in this house. Time is now to bring integrity to this house. Time is now to ensure that Ugandans respect us, and that once we are given responsibilities, we must act responsibly, and we must respect each other. And therefore, Right Honorable Speaker, I invite other colleagues to join me so that we do what is necessary to bring sanity to this house. Thank you.
Thank you. Seconders, today I'm not picking you. If you know you are seconders and you've been talking about this matter regularly, I won't pick colleagues who have not been. So I'll go to Honorable Byanyima. Then I add Honorable Kanuzu and Honorable Ababiko.
Thank you. Thank you, Right Honorable Speaker. Thank you, honorable colleagues. It's a painful job to do something we are going to do today. It's a painful thing. I have never done it here. It is painful. But above all, treat other people the way you want to be treated. You can't treat others as if they are not human beings. We are all members of parliament. Honorable Namuganza Princess, being a minister, she's a member of parliament, but she has added responsibility, which anybody can take. To me, I feel that a leader, when you permit something, it becomes a culture. Like you have done since the beginning of this parliament, being on time at 2. It's a culture. But I think Namuganza has taken a culture of undermining everybody. Mr. Speaker, I can't imagine somebody who can't say sorry to anybody. Honorable Namuganza came to a committee, which I sit on, physical infrastructure. We are presiding over housing and lands. She came and walked off on us. I followed her. As a father, I told her, I said, most of you people, by the way, you are honorable daughters and sons of mine. So I told her, I said, that's not the way things are done. The decorum of parliament does not require you to behave the way you are behaving. Go back to the committee and answer questions. She said, who are you? Here, I would be the last person to come and get involved in this censure. I know the bitterness of what I whipped. It's terrible. But she has caused. I appeal to everybody. Let us all be counted to vote against indiscipline. To vote against indiscipline. All members of parliament, we are equal. Me, I respect this parliament because you all respect me by virtue of my age and, you know, and seniority. And I respect everybody. Who is Namuganza? Recently, Right Honourable Speaker, recently, which is very rare, I saw the President saying, I am sorry for people who use the Entebbe Express and Northern Bypass because of this insecurity around, I am using that route. He apologized to people. That yes, he said it. He said it. He said it. So, when I see any of us here not having that humility of saying sorry, I, for one, in most cases, I disturb some of these ministers. But I've visited about 4 ministers early morning and I say, I am sorry for what I said about you, but forgive me. That's the decorum of parliament. That's the etiquette. She said we have never been oriented. We were oriented. We were oriented. But it is her who is uncultured. Mr. Speaker, all of us respect you, despite your age, because of that appointment and the power you have. Charity begins at home. To me, Mr. Speaker, I would appeal. In 1998, I stood here moving a motion of censure. You could drop a pin, drops down, and you could hear it. Everybody came. But we were surrounded by people who wanted to beat us. Surrounding this parliament, we have the freedom. Let's do what we are supposed to have done yesterday. Let's move a censure and discipline one of us. Let her come back on the back bench. It might be a mistake, by the way. There are some people who are appointed. They don't go the back, become backbenchers. They become ministers. And they feel they are on top of the world. No. This should stop. Me today, I understand Vyajima. From Bukanga North in the Central District, I have voted for a censure. I support the committee and I call upon you, please let's be together and discipline ourselves. I thank you.
Thank you. Honorable Kanusu. Lola.
Thank you.
Colleagues, we have a member on the floor. Honorable Kanusu Lola.
Thank you, Mr. Speaker. I would want to thank you for this opportunity. First of all, I want to say that as members of parliament whose principal job is to make laws, we must respect our rules of procedure. Our code of conduct, Appendix F, paragraphs 3 and 4, are very clear on public interest and public trust. Our behavior has brought public ridicule to this parliament. Mr. Speaker, I sit on the Rules Committee, and I don't want to repeat what happened in the Rules Committee when we were supposed to interface with the Honorable Namuganza. It is very ironical and very hypocritical for us to sit here and make laws and expect the citizens of this country to abide by those laws when we cannot abide by our simple rules of procedure. Mr. Speaker, this is not just about Honorable Namuganza. It is about our rules of procedure. How can we be so hypocritical to tell other citizens of this country to abide by the laws we make when we can't abide by simple house rules? How can you be asked to come to a committee of parliament and you say you cannot appear before such a committee? You disregard the committee of parliament. How? That was the rules committee, which is a committee of parliament. You don't appear. You make us sit for 2 hours. And then they put a select committee. You don't appear. Right, Honorable Speaker. My simple appeal is one. As the presiding officer, please, we must obey the rules of procedure. If we don't do that, we are bringing shame to this house. We are going to be a laughing stock in this country. I thank you, Mr. Speaker.
Thank you. Now, honorable colleagues, Honorable Lola has touched a very important issue of disrespecting committees. We have one case. You see, time is a very good judge. We had a case of the Kano Kaka Bajenda when he was the director ISO. And he said he can never appear before Parliament. And the minister in charge also supported him, said you can never appear. Now, as fate would have it, he's dropped as ISO and appointed as ambassador. So he needed to appear before Parliament for approval. So, when his case came, the speaker advised him, said, but you said you can never appear before a committee of parliament. So, now what can I do with you? So what you do? You first go and appear before the other committee. And of course, he tried his shenanigans, tried to find a way of mobilizing. Members remained steadfast. What ended up happening? He ended up losing his position as ambassador. So when you're here, even when you're a backbencher, even when you're strong, even when you're just an innocent member of the public, please just appear. And if Parliament, what they are saying is wrong or what, challenge it. The President usually emphasizes by saying that if it's about talking, I can talk and I challenge you. So that was a very important point. Honorable Babiku, you are next.
Thank you, Right Honorable Speaker, for this opportunity. Right Honorable Speaker, I have carefully listened to the report and I'm dispirited because, Right Honorable Speaker, Parliament is one of the highest institutions in this country and a lot is expected from us. For us to reach to this level, a thorough sieving has been done. And any disrespectful tendencies by one of us taints the image of this institution. More so from a honorable minister. Right Honorable Speaker, what I have listened to me tantamounts to abuse of office, tantamounts to assuming our government, assuming the appointing authority, an entire house in which we are seated. Right Honorable Speaker and colleagues, it's good at this point to have a common front to say no to indiscipline, to say no to characters that taint all our images. Right Honorable Speaker, Therefore, I support the report that this single person be treated in a way that will not continue to taint our image and that of our... Secondly, Right Honorable Speaker, as a woman, I am in pain. I have been a member of OOPA since I joined this parliament. This is my 11th year. We have been in advocacy to ensure that more women are brought on board. And all of us as women strive to protect positions given to us. When others take it for granted, Right Honorable Speaker, it is an abuse for all of us as women, not only in Parliament, but in the entire country. Right Honorable Speaker, therefore I support the censure motion to a person who is diverting this cause on behalf of the women. Right Honorable Speaker and colleagues, I am so hurt by the response made by this same person when the Honorable Prime Minister requested her to apologize. You are a junior minister and you cannot listen to your Prime Minister. What do you expect from others who are not even cabinet members? Right Honorable Speaker and colleagues, it is an indiscipline if we don't regulate. It means we shall have no regard for each other. We must follow protocol. We must respect each other. Whether you're a minister or not, we all have our rights to be respected, and we should do so to the others. Right Honorable Speaker and colleagues, you cannot be of a quality leader if you don't respect yourself. We must be exemplary leaders. Right Honorable Speaker and colleagues, I don't see any. How do you be in fights throughout your life in institutions? Is that your trade? Is that what you want young girls and boys to learn? That when we become leaders, we are supposed to fight everybody? Right Honorable Speaker and colleagues, I support the censure motion. Thank you so much.
Honorable Fox Odoi, followed by Honorable Bigger Rose, and Honorable Tinka Simiri. Then.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I sat here this morning and painfully listened to the report of the Select Committee. Painfully because we have before us an example of a leader who has no respect, who has no regard, number one, for authority, number two, for processes. And in all civilized societies, you have to respect authority, you have to respect processes, and you have to respect institutions. That is a hallmark of civilization. That is actually the beginning of civilization. When you are a kid in a home, you must respect your parents. When you are appointed a minister, the first thing the Honorable Minister should have learned is that there are 4 control centers for a minister. Number one, a minister is answerable to the courts of judication, like we all are. Number two, she's answerable to the president, the appointing authority. Number three, she's answerable to the Parliament of the Republic of Uganda. And number 4, to have voters. But here you have a person who has no regard for her voters. She has no regard for the president who appointed her. She has no regard for the Parliament of the Republic of Uganda. And she has absolutely no regard to processes. Now, at law, whatever is not controverted is admitted. Now, we have before us a report that has allegations and evidence to prove the allegations. We don't have her side of the story simply because she has no regard for processes. She is not here today as an act of absolute arrogance. So you have a person who is on a suicidal mission. And our only duty this afternoon is to give her a long rope to hang herself. Honorable members, I invite all of you to vote to right honorable with
these colleagues on the debate. I will not allow information. Let's just allow members to flow.
I invite all of you honorable members to speak with one voice, that for as long as we are in this house, we must have regard for authority, for processes, and for one another. Let us aid the Honorable Namuganza to hang herself.
Thank you.
Thank you.
Honorable Bigaros, and then Honorable Tinka Semire.
Thank you. Thank you, Right Honorable Speaker. I stand with pain as a true representative of the most rural woman. Right Honorable Speaker, if I heard well, everyone refers to the Right Honorable, to the minister as princess. At one time, I was a princess of the Lugbara Kingdom. And the protection, Right Honorable Speaker, I need your protection. Yes, ours is appointed. Right Honorable Speaker, at a level of a princess, you expect a lot of dignity, respect, and value for humanity, because you represent and carry the image of your kingdom. But honestly, whatever my sister was doing here on the floor of Parliament did not reflect anything in that address of a princess. Leave that alone. As a Lugbara and an African, a woman is supposed to have all the respect and be the image of her home. And she didn't show that she is the image of that ministry. Handing over the state ministry of lands to her is an insult to this country. She doesn't deserve to sit there anymore. Even to say a person of my caliber still needs to go for further orientation is the only abuse to the people of Terego. The president did say that he was picking only the fishermen and fisherwomen, but she has given us the worst example of fisherwomen. And besides, to my party NRM, we can't continue seeing this kind of caliber to show a bad image of this mighty party. Therefore, we didn't choose to be at the back bench. Some of us are holding 4 degrees but no diploma. Therefore, she is better placed to sit at the back bench. I therefore support this sense of motion. Thank you so much.
Thank you. Honorable Tinka Semire. Then Honorable Segona, Honorable Mwijiche, Honorable Semji.
Thank you very much.
Thank you.
Speaker.
Colleagues, let's listen to our colleague, please. Please.
Thank you very much, Right Honorable Speaker. My honorable colleagues.
Colleagues, let's listen to one another, please. Please.
It is with pain that we have to move this indictment this afternoon to one of our colleagues. The colleague indicted before us has been in this house for a long period of time, beyond one term. I have had the privilege of sharing a term with her, and I know her conduct. She survived that. Maybe she found a soft spot in the last parliament, but I think she took it for granted. She thought business was as usual, that she can disparage parliament, disparage the presiding officers, members of parliament, and she walks away. During our inductions, where she had the privilege to attend, they asked us that when, as a member, you have a disagreement with the speaker or any other person, find that person in the chambers and sort out this matter. We should not have even, this motion should not have found its way on the floor of the House. This matter should have been sorted somewhere in chambers, because she was talking about members of parliament who did not understand what they were doing in the select committee. She should have gone to the chairperson. First place, chairperson, you conducted this investigation. Did you address your mind to this? Is this true? And she would have sorted it out at that level. Then also, if she did not get the best remedy, she should have gone to the speaker. There are two speakers presiding over this house. She ignored everybody and went on the frail, the spree of abusing everyone. They gave her a chance on the floor of the House. The leader of government business invited her to just say sorry to the House. She ignored everyone. They invited her to the committee to defend herself. I have seen in the report my colleague has read here, they were citing authorities. She should have had the opportunity to raise even better authorities than what they were citing. She ignored it. So you members of parliament, what can you do to such a person? In the circumstances, she have waved off her chance to defend herself. Do you want to defend her? I am being asked, Right Honorable Speaker, that I close the debate and move that a motion be put, that a question be put to approve the committee report, and we proceed to vote at the personam procedure and declare that this house has code of conduct.
Is the motion seconded? Yes. I now put the question that the debate closes. Those in favor say aye, and to the contrary nay. The ayes have it. Debate closed. Motion. Motion. There's a motion on the floor.
Right Honourable Speaker. Right Honourable Speaker, I want to move a motion under Rule 16 of our rules of procedure.
Order. 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 Order.
Order, Mr. Speaker.
Order. Please, colleagues, please, let's listen to one another. We have a member on the floor. Honorable Sarira.
Yes, right on, Speaker. I want to move a motion under Rule 16 to suspend Rule 10 to suspend Rule 99, Sub-Rule 4. Sub-Rule 4, right on, Speaker, says the Speaker shall direct the doors to be locked and the bar drawn, and no member shall thereafter enter or leave the house until after the roll call has been taken. Right on, Speaker, I move that this rule be suspended to allow free entry and exit in the process of voting, but also for health reasons. You cannot close this place. It's very small and we are very many. So in the circumstances, right on, Speaker, I move that this particular rule be suspended as the voting takes place. I beg to move, right on, Speaker.
This rule is not entrenched as per Rule 16. It's not an entrenched rule. So it's a rule which can be seconded by, suspended by the House. So is the motion seconded? Honorable Chemaswet, Honorable Serwani, Honorable Nwagaba, and many members. I now put a question that Rule 99, Sub-Rule 4 be suspended. Those in favor say aye, and to the contrary nay. Semuju?
Rule 109, under which this process is being conducted, requires that, and I know you know, Mr. Speaker, that the decision is communicated to the President within 24 hours after a decision is taken. Reading that rule with Article 107 of the Constitution, I want to raise the following procedural issues. This Parliament, and I'm referring to Parliament as an institution, not the 11th Parliament, censored ministers, but they were reappointed. That is one. The Article 107 also speaks about the state of the President. With all the things that have been said here about Namuganza, why did the President appoint her in the first place? I'm talking about 107. So the procedural issue I am raising is whether we should not consider actualizing 107 by periodically examining the state of the President.
Honorable colleagues, please, let's listen to one another. Colleagues, let's listen to one another. Honorable Semuju, your procedure matter can only apply because it's under Rule 109, Sub-Rule 3. It only refers to where the motion has been carried. Now, we have not yet voted. We don't know whether the motion has been carried or not. So, your procedure matter fails on Rule 80, which is anticipation. Because you're just anticipating, you want me to rule on a matter where you're just anticipating. So I'm constrained, my brother. I'm constrained. let's first do the job, and the moment the motion is carried is when your issue can be raised. I thank you. So now, colleagues, yes, Rule 109(13), it requires that indeed we do vote on the matter, and like we made it very clear, Rule 99 is very clear that it's by roll call when we are censuring a minister. So, and the bar is very clear. Article 118 and Rule 109. You must get 50% and above of all voting members of parliament. Currently, we have 527 members of parliament, meaning the motion can only succeed if we raise 265 votes in favor. 265 votes in favor. So please listen to me. Now I'm taking you through the procedure so that we know what we are doing properly. Please, colleagues, okay? Listen to me. So we need 265 because I've checked with the clerk, the members we do have who are voting members. Okay? So we have to be cognizant of that. And then, colleagues, under this rule, we are going to make a roll call. And like I had earlier guided, with a roll call, any member who is attending can vote. So meaning even members who are attending by Zoom can vote. But for members, who are voting via Zoom, I'll need them to be on video. I don't want anyone to go and make allegations that we concocted voices, and also it must be put on record that I have called out the Honorable Namuganza to come on the floor as required by Article 118, Clause 6, and Rule 109, Sub Rule 3, to come and respond to the allegations, and she has not turned up. So it has to be captured that we gave her a chance to be heard as required by the Constitution and the rules, but she couldn't turn up. So with that, clerk, ensure the lists are ready. We shall have 2 clerks, one voting, one recording the votes for yes, and the other one recording the votes for no. We have the lists ready. We shall be reading properly. And the question which I'm going to put is that I now put the question that the motion for a resolution of Parliament to pass a vote of censure against Honorable Persis Namuganza Princess, State Minister for Lands, Housing and Urban Development, be adopted. This is not for aye or nay. Each one of you will have to respond individually. So for now, I will direct the clerk, the sergeant at arms, to ring the bell for 5 minutes. I will call the sergeant at arms to ring the bell for 5 minutes to come all of you in here. Before we even start voting, I'm supposed under the same rules to again repeat the question to you. And then I guide you so that those in favor will say yes and those against will say no. Okay? I will repeat the question after you have all converged inside as required under the rules. So we have a short break of 5 minutes from which all of us should be inside, and we start on the voting process. So Sergeant at Arms, ring the bell.
Leaders who care create a good learning environment.
Because a good school equals a better life.